Hello, my name is Sydney Wilbeck, and the case I will be discussing is Sandison versus Michigan High School Athletics Association. First, I will provide some background information on the case. There are two plaintiffs in this case, and they are two individuals that are high school students and high school athletes. However, they do go to different high schools, so this is a bit of a combination because it's two separate situations, but they're very similar. These students are having the same issue. So, one is Ronald Sandison and the other is Craig Stanley. Now, the basis here is both of these individuals were diagnosed with learning disabilities at a very young age, both around the age of kindergarten. Ronald Sandison, the textbook explains that he was enrolled in what they called ungraded kindergarten, but it doesn't exactly specify whether this ungraded kindergarten was specifically for individuals with learning disabilities or maybe it was an option for all students or parents. It doesn't exactly specify. So what it says is that Ronald Sandison attended ungraded kindergarten and then attended graded kindergarten. Therefore, he was 7 as opposed to 6 when he started. Craig Stanley, on the other hand, it was kind of similar. He was basically just retained in kindergarten, typical kindergarten, and did it twice. So he is facing the same thing. So the basis of this is that both of these students were diagnosed with learning disabilities at a young age. They were therefore retained, making them a little bit older than the other students in their class. This was not an issue until they became seniors in high school, which is where this case comes to play. Both of these individuals were both cross country and track and field athletes for their respective high schools. Now, the problem is, although they have participated for the last 3 years, now that they are entering their senior year, they are 19 years old, which is a problem in the state of Michigan because the Michigan High School Athletic Association states that student athletes may not be over the age of 19 and continue to participate in sports. They say that there are safety concerns as well as fairness of competition concerns. So that is the issue the plaintiffs are facing. Because of the aforementioned retention due to their learning disability, they are filing claims that they are being discriminated based on their learning disability and they feel that they should be able to participate. I'll get into specific laws and regulations on the next slide. The defendant here, this is a little bit tricky. The defendant is technically the Michigan High School Athletics Association. It is the schools too, because they are enforcing these rules. However, both high schools, both athletic administrators here are showing support of their student athletes, and they are on the side of the student athletes. Their understanding of the law is that this is not a scenario that would be unfair or unsafe. Therefore, they are in support of their student athletes. So although yes, they know they're having to enforce this rule, they are on the athlete's side. And so everyone is fighting against the defendant, the Michigan High School Athletics Association. Moving on to the laws and regulations. First, we have the Rehabilitation Act of 1973, or Section 504, as we will commonly hear it called, and then Titles 2 and 3 of the Americans with Disabilities Act. There is one other piece of legislation that the text doesn't mention here, but I believe it's applicable. The Individuals with Disabilities Education Act. Now, this act states that students are supposed to have free, appropriate public education. And part of this is that these students should be in their least restrictive environment. Now, what this means is they should be in the environment where they learn best. And when I say they, I mean themselves as an individual person. So even in terms of a student with a disability, the criterion here is not disability or age or any other factor. Two individuals could have the same disability. However, their least restrictive environment, whether they are in a special ed classroom or in a traditional classroom, that could be totally different because, again, we should be basing that on the individual and not their disability. Now on to the arguments. These arguments are pretty self-explanatory in this case. The plaintiffs or the students here, they claim that the barring of their participation in cross country and track is due to their disability because they believe they were retained because of their disability. So, because they were retained, that is the reason they are 19-year-old seniors. And because they are 19-year-old seniors, they are being barred. Therefore, their interpretation of the law is that it is the disability that is causing the issue. Therefore, the argument is discrimination due to the learning disability. However, the defendant does not see it that way. The defendant, or Misha, in this case, they argue that this is not discrimination, it is um, prohibition from participation because of specific criteria related to safety and fairness of competition, which is the way they believe the law should be interpreted, the way that the law is written. It doesn't, they say that things that have happened in the past like this, whatever the cause is not relevant here. They are looking more terms in terms of today and in terms of safety and fairness. And this law states that they believe that if an individual is 19 years old, that it is not safe and it does not create an atmosphere for fair competition. Therefore, these athletes should not be able to participate. The court decision was in favor of the plaintiffs. However, the textbook goes on to say multiple reasons why they disagree. So as I continue, I will describe why our textbook disagrees with what the court has decided. So here I have listed the 4 elements of Section 504, and the textbook describes all of them and how they apply, but the most important one to look at is number 2, which states that the plaintiff is otherwise qualified to participate in the program. The big argument here on the side of the defendant in the case and in the textbook is that this does not apply. They are not otherwise qualified because the issue, again, is the age, or the textbook uses the phrase the passage of time is the issue. They have turned 19, that is their age, it is the passage of time, and that the issue is not their learning disability. The text also mentions the undue administrative burden, and it goes on to explain, as I've pulled one direct quote here, and there is more information listed as well, but I believe this pretty much sums it up. The text explains that it is an undue burden to require high school coaches and hired physicians to determine whether all of these different factors would really be unsafe or unfair, because they would, in their opinion, they wouldn't be just looking at one athlete, okay? They would have to look at that athlete. They would have to compare all of the factors, mental, physical, social, emotional. They would have to compare all of these things for this athlete along with all of the other athletes on their team, along with all of that of the opposing teams. And their understanding is that that is not feasible. Therefore, they do not believe it is something that Misha should overturn or that these high schools should be allowed to do. This is tough. This is certainly tough for the athletics activities administrator, much like many cases I'm sure that we will discuss in this class. The issue is, of course, as the administrator in this situation, we want to support our student athletes, and that should always be our highest priority is supporting them in any way that we can. That's what we're there to do. However, we also have to follow rules and regulations and laws and do things by the book. So unfortunately here, even if the administrators in this situation personally were on the side of the athlete, it is their job and their duty to follow the laws and regulations. So unfortunately, even if they wanted to allow these student athletes to participate, I believe the right thing to do would be to go by the Michigan state laws and do what they did and basically support them. Now, if they didn't, then again, that's up to the school district. But because in this case, the case explains that the schools were in support. So if that is true, then I would say the right thing to do here is to support them through it. However, again, they would have to go with what the decision was, because their job is to follow the laws and regulations while also doing what's best for the student athletes.